Good morning. Last time I talked to you about unlawful arrest, I discussed with you what it takes to be an unlawful arrest first and what the remedies for the unlawful arrest are available to the suspect, to the person who was the uh, arrested person. And those included suppressing any evidence at a suppression hearing, and or going after the officer or officers with a civil rights lawsuit. And weirdly enough, I mean, I guess I should suspect it at this point, but weirdly enough, people immediately jumped into arresting the officer for the unlawful arrest, charging the officer and convicting the officer. Excuse me. And there were two posts that were relatively close to each other, close enough that it made the irony even more delicious. One person posted a link to a justice.gov news release talking about a police officer, I think in Tennessee, back in 2018, that was convicted of a federal crime. I believe the federal crime was 18 U.S.C. 242, but they didn't state what the crime was in the release. So the officer was convicted essentially for, specifically for arresting someone without probable cause. And then immediately below that, or I guess above that, I don't know, it depends on how you order the list, but relatively close to that, there was another post of a person complaining that officers have, and I'm using the commenter's words, de facto immunity from arrest, prosecution, and conviction for unlawful arrests. And here's the thing. Here's what's going on. When there is the probable cause hearing, or the grand jury hearing, whatever you want to call it, the officer is not on trial. The police officer who made the arrest is not on trial for that particular action. It's part of the suspect's trial. That's what's going on there. It's part of the trial process for the suspect. And when let's say, for example, the judge determines that there wasn't probable cause, that is great for the suspect, but that's essentially meaningless as far as any potential prosecution of the actual officer. Because first of all, the officer has to be charged with a crime. Just arresting someone and having it be determined that there wasn't probable cause for the arrest isn't in and of itself necessarily a crime. There's going to be some sort of other crime, like the 18 U.S.C. 242 is it's very similar to 1983. It's the deprivation of rights under color of law or something like that, but it's where a state actor will deprive someone their rights. I don't know if anybody remembers the Mississippi burning case where the civil rights activists were killed. That was 18 U.S.C. 242. So first you have to find a crime to charge the officers with, and then second, you have to the DA or whoever, U.S. attorney, whoever is going to be bringing the charges, is going to have to come to a determination that this is going to be a case that they can win. Cases can proceed on probable cause, but in order to get the win, it's just a waste of time and effort if the DA or the U.S. attorney doesn't think that they can actually prove beyond a reasonable doubt. So what has happened so far in the case, at the time where the initial suspects at the probable cause hearing was found, the arrest was lacking probable cause, nothing has happened yet in a criminal case against the officer. So what the DA is going to have to do is bring charges and believe that they could prove that the officer, beyond a reasonable doubt that the officer did not reasonably believe he had probable cause at the time of the arrest, among other things, because they're going to have to prove mens rea of some sort, again, depending on the law, that they're upon the statute they're charging the officer with. And there are, generally speaking, going to be justifications that are going to be available to the officer. And it's not just to officers. Like, for example, in Texas, there's a justification that allows for reasonable mistakes of fact. And it's available to everybody. Everybody who commits a crime, if they've committed a crime, but they made a reasonable mistake of fact. Like, for example, you walk into the coat closet of somebody's house. You know, you're there as a guest. Everybody's given the host their coats and everything, and the host has put the coats in the coat closet, and you're ready to leave. You go into the coat closet and you take someone's coat, right? You think it's yours. You've made a reasonable mistake of fact, and you walk out with it. Have you committed a crime? Possibly, but your reasonable mistake of fact is going to be a justification for committing that crime. And that same defense is available to officers. If they make a reasonable mistake of fact, their reasonable mistake of fact that, you know, there was probable cause for the arrest, well, you know, there you go. That defense is available to them. Additionally, probable cause in itself is a very kind of nebulous sort of thing. It's a real thing. It's a kind of a specific thing, but it's also an unspecific thing. The Supreme Court and courts in general have not put like actual like percent probabilities on it. So it's, you know, it's the judge is determined at the probable cause hearing that the officer did not have sufficient probable cause. Does that mean that the officer had not even a shred of probable cause? Because you hear the judges say there's not sufficient probable cause to justify the arrest. But it's a bit of a questionable line. I mean, on one day a judge might go one way on a wobbler, on the other he might go the other way on it. It's not a specific thing. You can't say there was 34% probable cause, which is sufficient. There was 33% probable cause, which is insufficient, whatever. You know, you can't put exact numbers on it. So there's some squishy, there's some gray area. So what the DA would have to prove beyond a reasonable doubt is that there was not probable cause, which is 99% of the time is going to be next to impossible. You know, for example, one of the examples I gave in the last video was that there was a 911 call with a hang-up. Officers responded. They heard arguing from within the apartment. They enter the apartment and they see the suspect standing about 3 feet away from the alleged victim, yelling at her, and she's on the ground. Well, is that sufficient probable cause for domestic violence, for criminal domestic violence? Maybe. I mean, that is questionable. I mean, have we seen any action? Was she bruised up? I mean, are his hands marked? It's a little squishy there. And the judge at that probable cause hearing, or the grand jury, whoever it was, I think it was a judge, because typically, well, I don't know. I guess if it was a felony, then it would be a grand jury, but I think it was a misdemeanor. So which would typically be a judge or a magistrate determining probable cause. But the thing is that two judges can go different on it. I guess that's where I'm going on it. So it's a lot harder. There's a lot more to prove after the judge says in the initial case that there was insufficient probable cause for the arrest. That's essentially meaningless to whether or not the officer committed an actual crime. Where you see officers convicted of these crimes are where there's just simply no probable cause, or where there's some sort of ulterior motive, and it's possible for the DA or the U.S. attorney to assign mens rea, criminal intent, to the officer's actions. Now, there's also another kind of aspect to all of this, and that other aspect is what is best for society. What do we want to incentivize as a society, and how do we want to incentivize it? And let me give you a couple examples of what I'm talking about. People get into car accidents all the time, and battery, you don't have to actually touch someone's person to commit battery. You could touch something that is connected to them. And so theoretically, like in car accidents, people could be charged with battery, with assault with a deadly weapon, with intended murder, attempted murder, something like that. So there are lots of things people could be charged with, but you'll notice that 99.9% of car accidents do not involve any criminal elements, do not involve any criminal actions, I should say. And that's because it's easy to prove fault in a car accident, but it is a lot harder to prove criminal intent in a car accident, or in a car. It wouldn't be an accident at that point, in a car collision. So that's one factor that people should be aware of. But as far as looking at what's best for society, doctors, surgeons specifically, constantly make mistakes. I've done 2 medical malpractice cases, and one thing that I have learned in doing medical malpractice is that it's not the normal mistakes that the surgeons make that you can get them for. It's not malpractice to make a surgical mistake that is a common surgical mistake. When you're going in for some sort of an operation, they'll list the normal kinds of complications, and a lot of those normal complications are mistakes made by the surgeon, just minor mistakes. Those if somebody else cut into you, that would be battery. You don't want that particular thing. You want just the cuts that are necessary for the surgery. And then there's another thing called medical battery, which is a tort, just in case anybody's wondering. It's not a criminal thing. But that's where the surgeon operates on the wrong thing, or does a procedure that you didn't ask for. Like, for example, you go in to get like a kidney removed. Let's say one of your kidneys goes bad and needs to be removed, or is cancerous, or whatever. The surgeon goes in, removes the kidney just fine. There's no complications or anything, but whoops, he took out the wrong kidney. Well, that is like, you didn't want your good kidney removed at all. It wasn't a simple mistake. Everything was wrong. That is, he sliced into you and cut out one of your kidneys. If Joe Blow on the street sliced into you and took out one of your kidneys, obviously that dude's going to prison, right? But not a surgeon. Why not? Well, as a society, we don't want to stop people from being surgeons. We don't want to disincentivize them from being surgeons. And if they were exposed to criminal liability every time they made the slightest mistake, or even a fairly major mistake, but without that kind of criminal intent, if we expose them to criminal liability every time, then as a society, we would run out of surgeons really quick. Now, that's not to say that surgeons have de facto immunity from assault or battery cases. They obviously don't. If a surgeon goes outside of the scope, if they could prove that the surgeon lopped off you go in for an appendectomy, the surgeon goes in there, he thinks that you're the guy who slept with his wife, and instead of giving you an appendectomy, he castrates you. Well, guess what, kids? If they could prove that intent, if they could prove that it's not just a mistake, that it wasn't just a mistake, then they're going to go in there and they're going to get that doctor. They're going to throw the book at him, right? And so that's what you see. You see the same thing with police officers. If they make a mistake that's kind of reasonable within the scope of their duty, within tolerable limits of error, then fine. You can still sue them. You might even be able to recover from them. But we're not going to expose them to criminal liability for that. On the other hand, if they exceed those kind of tolerable norms, if they go outside of them, if they do something egregious, if they do something that is kind of more blatant and in your face wrong, then as a society, we're going to go after them. So I hope that makes sense. But the big thing that I wanted to point out was that just because a judge has determined in the suspect's case that there is no probable cause, that has no bearing on criminal liability for the officer. There's going to have to be a separate case against the officer. They have a much higher standard of proof against the officer because it's not a probable cause hearing for the officer. It is now a criminal trial. And they have to prove, one of the elements they're going to have to prove beyond a reasonable doubt is that not only was there no legal justification for the arrest, but that the officer wasn't making a reasonable mistake of fact. So, I mean, there's just a lot of hurdles to get over to get that conviction on a cop. So, for unlawful arrest. So I hope that helps. Thanks for watching and have a great day.